There we go. All right, recording's up. So it is October 10th, and this is the meeting of the PSRB standards work group. Harris, thanks for coming. I know that we're maybe expecting some others and expecting some written feedback from some other group members who couldn't be with us today. Just to kind of recap where we are, we've got some considerable work done on the civil commitment standards, and I took the work that we had done on those standards, combined them with the, we'll call it, crash course in PSRB that you all gave me a couple of weeks ago, and put together the draft standards document that I emailed out to you all earlier this week. So I'm going to share my screen now so we can take a look at that. And then, you see that okay?
Yeah, I've got my copy here.
Great. All right. So if you want to just, we can, if you have any comments on the kind of intro paragraph up here, feel free to email them to me. But I think our time is going to be best spent going through the standards themselves. So if you don't mind, we'll start at 1.1, the role of PSRB counsel. And this was pulled largely from our discussion.
Okay, so are these mostly civil commit standards? Because they started out sounding like civil commit, and then when I got further into it, some of them looked like they were more criminal stuff, from criminal proceedings.
Mm-hmm. Both. So the criminal standards were pulled to make the civil commitment standards current draft, and we're going through those in the civil commitment group and refining them to be civil commitment standards. And then those standards were pulled over to this draft to make this draft, and we'll refine these from those to be PSRB standards. So you're two removed from criminal, but it is in there. It is also my experience based, so a lot of what I write is going to sound like that.
Okay, yeah, I just wondered because some of it seemed to be kind of going back and forth at times, and so I was wondering if it was there was a combination. Okay.
Yep, but feel free to point out wherever it is overly reliant on criminal or civil commitment standards. You and the rest of the group are the experts, and I am certainly not. So, what are our thoughts on the role of PSRB counsel? And then also keep in mind, I suppose, the bold-faced print is our kind of bottom line, and then our commentary lets us kind of explain our bottom line a little more, but is not necessarily going to be binding on folks.
Well, best practices won't be binding. You're saying they're
right.
They're aspirational. Okay, that's
right.
Because some of this, like later about meeting somebody within 24 hours of an appointment. Frankly, that person could be anywhere in the state of Oregon. And,
okay.
And we don't, until they get to the hospital, there won't be a hearing. And the PSRB doesn't really do kind of formal appointments. They put out a list and your name is on it. So anyway, I know that's ahead, but that's one of the things in my mind that sort of differentiates it from a criminal matter where you go to court, there would be some kind of an arraignment, you'd be appointed at that time, and you'd immediately meet with the individual. So anyway, okay.
So, I mean, we can start there. That's fine.
No, I'm happy. I don't want to go out of order for you. That was one of the reasons for my initial question about, is it just civil commitment? Looks like it has some criminal stuff in it, and so I just wanted to be sure.
All right. Well, we'll tag that to come back to. I suspect we'll get there today, but All right. So the role of PSRB counsel. Provide quality and zealous representation at all stages of the case. Ensure that clients receive competent and conflict-free representation. Any trouble with any of that bold letter language there?
Well, okay, so the one I have says so is this is the bold standard 1.1?
Yep.
I on mine it says the lawyer for the client in a civil commitment case should provide quality and zealous representation at all stages of the case, advocating at all times for the client's expressed interest according to Oregon rules of professional conduct. So am I looking at something different than
You may be looking at something different.
no,
You may actually be looking at the civil commitment standards. Those were sent around to the group about the same time.
oh, all right. Well then, all right. So let me.
That would explain why they're very civil commitment forward, though.
Well, yeah, and that's my assistant. I was in beautiful downtown Junction City all day yesterday, meeting with clients. So this is what she.
Wonderful.
Okay, so let me take a look at this. Okay, well, that sounds. The standard sounds. Well, okay. So here, this is the screwy part about this area of the law, and the second paragraph: the lawyer must determine whether the client has sufficient capacity to understand and form a lawyer-client relationship, and whether the client is capable of making reasoned judgments and engaging in meaningful communication. As a criminal standard, I mean, I get that by virtue of the fact that all of our clients have been, I'll use the word sidelined, but have taken a different path where they've been determined to have a mental illness by a court. There's going to be a good number of folks, or there's going to be a number of folks that may be actively mentally ill or don't have the capacity to do those sorts of things, have really good decision-making capacity. And so I don't know. I mean, from my perspective, and working with people whose, judgment may not, may be significantly impacted by a mental illness, my job isn't to, if it was deemed that they didn't have capacity, a lot of these hearings just would never happen.
Sure.
I see my role as an attorney is not to substitute my judgment for a client's, but to work with a client to educate them about, these are your options, these are the potential outcomes. What do you want to do? And so I'm a little concerned just about that one statement as to, kind of what, so you make the determination that about sufficient capacity, kind of where does that, in terms of
and I think
controllable judgments.
I think that, so the way it's written, the idea was that line, you have to make a determination about what your client can do, and then that feeds into the next two little paragraphs. So if your client has full decision-making capacity, you have certain obligations, and if they don't, you have certain other obligations. And then if they can't express their interests at all, you have the last paragraph in there.
Yeah. Well, so, and here's the other thing that, and I don't mean to be a contrarian, I just don't want to get tripped up. And this may be the best that can be done. And I certainly appreciate the work that you put into it. But my job as an attorney is to evaluate, a person's judgment or capacity. That's something that's, already been determined by a court that they were able to aid and assist, that they had capacity, at least at the time of the time they entered the plea. and were found GEI.
Mm-hmm.
So my opinion later on, let's say they have a cyclical illness like a bipolar disorder and they're actively manic. I can say, well, I don't think that they've got capacity, but again, I'm not medically trained, and what do I do about it except, um, we're not able to, for example, continue hearings based on the fact that my client's not competent to proceed. I mean, there's sort of an understanding that some people really will never be, or may never be,
Mm-hmm.
competent to proceed, and so the best that can happen is that maybe their illness can be put into partial remission, maybe in the case of a head injury, maybe never. Anyway, I just sort of throw these out again, not to be a contrarian, but just to kind of go,
Yeah.
ouch, I don't
No,
want
that's a good point. I
I
will.
don't misstep.
Yeah. I'll bounce back through that.
Okay.
Yeah. Let's see. Maybe we can add something in the commentary to help flesh that out. So the commentary, you're basically restating ORCP 1.14. Provide candid advice to client regarding successes and consequences of a particular position in the case. Give client information necessary to make informed decisions. I suppose we should add to the extent they can. Consult with the client if they want to waive any right or position.
Yeah. And that goes on all the time.
Yeah. Endeavor to build trust with clients, offer them comfort and understanding during their commitments. Assist client in planning for potential release as soon as practicable. After, I'm not going to use the term appointment. Does case assignment work better than appointment?
Probably.
Well,
I don't know. The
PSRB has the list that they send out.
Yeah.
Yeah. Yeah, I think that works.
Okay.
If you don't have a problem with it, I think it's clear enough.
Yeah. I don't want to overcomplicate it, and the agency does what it does too. So keeping them happy is important.
Yep. Lawyers should exercise reasonable professional judgment regarding technical and tactical decisions and consult with the client on the strategy to achieve the client's objectives.
Yep.
The education and training section. Be familiar with the applicable substantive, procedural, and administrative law, OAR Chapter 859, governing appearances before the board. The lawyer has a continuing obligation to stay abreast of changes and developments in the law and with changing best practices for providing quality representation in PSRB cases. Are there any other admin laws that are used in these cases other than the ones in the?
I think 859 is the critical one.
Okay. Okay. And then prior to handling any PSRB matter, lawyer must have sufficient experience or training to meet the OPDC qualification standards. So that one is pretty straightforward, but anything in there you see that you think we need to change?
No, I don't. I don't. And it's sort of funny how this has progressed over a period of years. It's just sort of irrelevant to this discussion, but I'm assuming that OPDC, and I can check with them, as we're training other lawyers to do these sorts of things. I want to be sure that it's we're all familiar with what those things are.
Yeah. Okay. To remain proficient, keep up with and monitor changes in the law. Try to stay particularly aware of decisions that impact the Oregon State Hospital and decisions in legislative bills that impact the Oregon State Hospital. Be knowledgeable about the state hospital systems, resources available to clients in the system, constitutional rights clients have while in the system. Lawyers should monitor the system for any changes that will impact clients. Should have knowledge of mental health disorders. Feel free to cut in if you have anything that needs to change in any of these.
So the one on bills related to the Oregon State Hospital.
Yeah.
There are, and I don't mean to be nitpicky, but there are tons of bills that relate to the Oregon State Hospital, from funding to all sorts of things that are not really relevant to the practice. And also, frankly, a bill may never turn into a law. So I'm wondering kind of why. And again, I sort of do this as a matter of course myself, but I don't know really how necessary it is as a standard.
That's why it's in the commentary section.
Okay, all right.
This is a good idea. You probably should consider it, but nobody's ever going to say, bad lawyer, you didn't know about this obscure bill that they didn't pass out of committee.
Okay, yeah, and thanks for that. You're right. It's a best practice. Okay.
Yeah. Be knowledgeable about mental health disorders, how they present, and the state mental health treatment system. Be aware of any county mental health options and where clients might be placed. Be knowledgeable about HIPAA rules and how they might impact your practice. And is it correct to say practice before the board?
As opposed to just practice?
Well, like if we were in a criminal context, I might say, criminal practice or practice before the court or trial practice or something like that.
Yeah.
This is probably overly nitpicky grammar stuff, but
yeah. I guess you could say, yeah, I don't, board I think is fine.
Yeah. Know the members of the PSRB and their backgrounds. Be mindful of the primary purpose of the board is public safety, and this might put them at odds with the lawyer's primary role of advocating for clients' constitutional rights. Maintain membership in state and national organizations that focus on educating and training lawyers. This one had leftover civil commitment language because are there any kind of organizations that deal with PSRB training or lawyers practicing PSRB work or anything like that you know of?
No, there aren't any organizations. It's there's so few, around the state that it's sort of word of mouth, and the board does trainings and so on, but the way they train people to view the world the way they want them to view it. So it's not always very helpful.
Gotcha. We'll pull that section then. Lawyers providing PSRB representation in PSRB cases should be familiar with key agencies and services such as the district attorney's office, office of city council, hospital staff, county behavioral health, private treatment facilities, services available as dispositional alternatives. This is another one that I just pulled over from civil commitment because I didn't know if there was anything like it in the PSRB group.
Yeah. So on this one, I made a note to myself. The district attorneys are sometimes involved, but really it's well, so yeah, district attorneys, I would say attorney general, because the attorney general 99.9% of the time represents the state.
Mm-hmm.
And then OSH, Oregon State Hospital. I think those are the, as opposed to hospital staff. I mean, it could be hospital staff, but I think including the Office of County Counsel and the district attorney, well, you can leave the district attorney, but anyway, it should include the AG, Attorney General.
Gotcha. Yeah, if the DAs are rarely involved, we'll just use the AGs.
Okay.
Do you ever do work, like, is there ever a county behavioral health folks involved?
Oh, absolutely. Yeah,
okay.
When we're talking about release to a program, the program is always represented.
Got it.
So I see it here, it says, at least on my draft, it says private treatment facilities and programs, along with other services and programs available. To me, I thought that was sort of included. The community programs are included, but I guess you could call them out specifically if you wanted.
All right.
They're all nonprofits that are contracted through the state.
Okay.
Or most all.
All right. The obligations of PSRB counsel regarding workload. This one has been pretty consistent through all the standards we're working on. Don't agree to take on more work than you can do. Yep. It is also fairly straightforward pullover from the rules of professional conduct. Have access to sufficient support services and resources to allow for quality representation. Evaluate the lawyer's ability to appear with clients when deciding whether or not to accept appointment on a case, appear personally for all critical stages of the case. And that's not getting into like how you appear. It just, the idea is don't rely overly on other lawyers to cover appearances.
Yeah, thankfully it's not.
And then when possible, appear in the same manner as clients. This one, I don't know if it's possible in the PSRB world. Are the hearings generally in person? Are they remote hearings? Are they?
It's yeah, one of the most, I think, sorrowful situations that I've encountered. Hearings were always in person, and with an occasional, when somebody was an outpatient, things were done remotely, but with the board in the room with the attorneys. It is COVID led to remote hearings or virtual hearings. The board said it would get back to doing in-person hearings, and then the board got used to virtual hearings, and it remains virtual hearings, which is too bad. So the board no longer appears with us. They're in their offices, homes, wherever they are. So
okay. And where are you when you're at the state hospital generally when you're appearing?
Yeah, I'm always at the state hospital, always in the hearings room. Okay. There are a couple of different hospitals. There's one in Junction City. So if I have a client one day in Junction, two hearings, one's in Junction City and one's in Salem, then I can't be both places at once. But we have it all worked out with staff, so
okay.
I'm available.
Okay. That drops us into the communicating with clients section. Let's change appointment to there. Appointment to the case. So the PSRB board emails you the assignment sheet, and you say, all right, I've got these 3 new people I'm assigned to. What is a reasonable amount of time that you would expect to get in touch with them.
With the client?
And just for the initial, hi, my name is Harris, I'm your attorney.
So the way okay, so that's a couple of questions. The way I work it is I'm at the hospital generally once a week in person, and anybody that wants to meet with me, all they have to do is just sign up or come on down, and so I meet with people at least once a week at the Salem campus, and at least once every 2 weeks in Junction City, at least. Sometimes it's weekly.
Okay.
So, so somebody could be at the state hospital and we could not be assigned, and we could still see them, which is not unusual. But in terms of we get a finalized schedule of when hearings are, usually no more than a week in advance. That's my experience. And oftentimes the board doesn't send a full file of exhibits and stuff until after that even. I've been doing it long enough, and thankfully have, and this is not just me, but it's any attorney that does something, that we work with the hospital and we work with the client, and if it involves contacting the trial lawyer, we get a good sense of what's going on in advance. And so for me, I would say, in terms of your question about when meet the client, I'd say it's usually about a week. I can say generally about a week prior to the hearing.
Okay. So you wouldn't go meet them ahead of having all of the hearing stuff?
Oh, I do. That's what I say. I'm there to informally meet them, and I talk to them all the time. But in terms of actually saying, okay, now I pretty much have a better understanding of what's going on because all the information has just been supplied to me and so on. So there are meetings.
Yeah, but this is what we're trying to get at here, is really that first meeting after the assignment. So like,
yeah, I can't say it'll be within 24 hours because it's
sure.
We just, I just don't know. So I work backwards really from the date of the hearing. It would be, and understand that a lot of these folks are, I mean, some of these clients my office has represented for 20 years, the people that are under the board for life. So we see them very frequently. And whether we receive an official appointment to the case or an assignment, we know we're going to be assigned. We know their attorney. So, we're in sort of ongoing communication with them. So I'm thinking out loud, which is dangerous. I'm just trying to think this through as to if you were trying to create a standard, what that would look like. Maybe we work, I don't know if this would be acceptable, but maybe you'd work backwards. Like, let's see, let me look here. Meet with the client within, I don't know, 7 days of their hearing. I don't know, does that sound correct? Because the person comes in, for example, a person gets revoked from conditional release. They have to have a hearing within 20 days. That doesn't mean they're at the hospital for 20 days. That means, they could be in process, or somebody who's placed under the board's jurisdiction. It doesn't necessarily mean that they're being sent to the hospital. They could be being held in jail or whatever. And so there's no way like we could meet them in Jackson County or whatever, drive all the way out there to do that. And it wouldn't be helpful. It wouldn't be helpful anyway, to do that in that setting when they haven't been assessed yet by the people that will be testifying at their hearing, by the doctors and so on and so forth. We don't have any kind of an admission history yet.
And when we say meet, we may want to clarify this, but when I'm thinking meet with, I mean, we'll want to take out the in-person interview thing, I think. But what I think we mean is just kind of figure out a way to talk to, let them know who their attorney is, that sort of thing. I don't think it has to be, I certainly don't think it has to be in person for this, because you're right, they will be all over the state.
Yeah. Well, yeah, and as I say too, because I am, or we are, my office is available, um, and at the hospital weekly. I mean, just to meet with clients, um, people can come down and talk to us anytime, or make an appointment for me to actually go to the unit, as long as they're not,
Yeah.
as long as their unit's not on lockdown for some reason.
Okay. Okay. That's helpful. I think we'll figure out a way to word all of that.
Okay, I appreciate that. Yeah, I think that
Yeah.
does require some more thought.
Yeah. Let me, just so I have a prompt for when I'm going back through this. Conduct conflict checks at the time of assignment. I assume you don't have a ton of conflicts by the time it gets to this.
Yeah, I don't know what the conflicts would be necessarily. It's not like we're representing co-defendants, or anything like that.
Yeah.
Uh,
Yeah. Do you think that's worth leaving in as commentary, or just it's
Now let's see.
not even a thing, so don't worry about it?
Yeah, where's the conflict part of it? Let's see. What is that?
It would be 2.1 under commentary,
Yeah, but
the first one on there.
Okay.
Lawyers should conduct conflict checks at the time of we changed appointment to assignment, and should continue to monitor possible conflicts throughout the case.
Yeah, I'd eliminate that. I don't.
Yeah. Maintain contact with clients throughout their commitment to PSRB jurisdiction. Use clear, developmentally appropriate language. Use an interpreter as required. Lawyers should elicit the client's point of view and encourage the client's participation in their own. Would it be in their own defense? I
Well,
guess they're
that's
defending from. Yeah.
Yeah, I think that's the best word I can come up with right now.
Okay.
I mean, it's not like they're being accused of something at this point, so they have to defend against something what they're trying to do, and I guess it's really preparation of their own. I guess
Yeah.
it's really of their release. Really encourage.
We just say participation in their own case.
Yeah, case is better.
Lawyers should be prepared to discuss the timeline of commitment to PSRB jurisdiction at their initial meeting, include ways the timeline may be reduced or extended. Be prepared to discuss collateral issues of commitment to the PSRB with the client. I think we decided to leave on immigration consequences, restriction of rights, impact of commitment on ongoing court cases, issues involving contact with family members, things like that.
Yeah.
Prior to all meetings, lawyers should be familiar with the requirements of PSRB jurisdiction, obtain copies of any relevant documents that are available, including any initiating document, hospital medical records, recommendations, reports made by agencies concerning commitment, law enforcement reports that might be available. Discuss the client's case with the treating psychiatrist to get a sense of the doctor's intentions. Prep releases of information for clients to sign and to seek records on the client's behalf. Be familiar with legal procedure the client will encounter. Be familiar with types of detention the client may be subject to, length of detention, and process for changing client's placement. There There is no right to counsel with a risk review panel. The lawyer should discuss the panels with client and provide client with advice on how to achieve whatever their desired outcome is.
Yeah, that sounds
Okay.
That sounds right. And understanding too that most, unlike unlike the trial court model, much of the evidence is provided by the PSRB. So, and this doesn't need to be included in a rule, but just as an explanation, when somebody uses a GEI, the board is very thorough about getting any damaging evidence it can get. You know, so they get the court order and they get the police reports and all that. So this process is kind of dumbed down. It's very different than what you and I might normally consider.
Okay.
So it's a bit easier than it might look.
Understandable. So we're about halfway through this. Do you want to break here? I can resend this to you so you've got the most updated one. And then if you and hopefully Allison and Bailey want to give me some feedback, written feedback on the draft, then we can use our next meeting to just kind of run through hopefully all of that. That might be a better better way to go about this.
Okay, if that's what you
line
like
by lining it.
Yeah.
Yeah.
That works better for you. That's fine.
Yeah, I think that might be more helpful at this point than just kind of line by lining it. And that way we have some indication of what areas we need discussion on.
Okay.
All right.
All right.
So I'm going to cut the screen share and the recording. Harris, thank you for being here and thank you for your help on this. I really appreciate it.
No, thank you. This is, it's always, especially at my age, it's always fun to be in on the ground floor. You realize that whatever is done here, other people will build upon. There'll be some head shaking and some hair pulling probably within a decade, but it's all part of a process. So it's good.
Yeah. And we'll go over these again next year. So it won't even take a decade for the hair pulling.
Well, I've got you beat on the hair pulling part so far.
There you go.
All right.
Thanks.